It is 7:45. Welcome back, everyone. A lawsuit surrounding window seats on United Airplanes is moving forward. A federal judge rejected the airline's bid to dismiss the case in a hearing yesterday.
The lawsuit was filed back in August from passengers who complained they paid extra money to sit in a window seat only to discover their seat had no windows.
United argues the term window refers to the location of a seat, and they never actually contractually promised that seats in the window position would have views outside. Joining us now, our chief legal analyst, Khalif Rhodes. I mean, it sounds a little humorous here, right? You say window seat, you kind of just assume there's going to be a window there.
Yes.
So where's the legal fine line here?
Well, there's no fine line at all with this case. I mean, obviously, you file a complaint, and the other side at some point will attempt to file a motion to dismiss along with their response. That's what happened here. The judge denied that motion to dismiss, and for a number of reasons. You request that it's dismissed because the party that's moving, I should say not moving, but petitioner, filed to state a claim that could be relief can be sought. Well, if you can show that, yeah, there is a question of material fact, there is relief that can be sought. I'm pointing to something in this situation. A breach of contract would be the easiest thing that I can point to. I contracted with you to get a window seat, not to get a seat closest to what allegedly would be a window if there was one. And so if you're telling me that that's your interpretation of our contract, we have problems. You shouldn't be able to decide that I don't have an issue. A jury should be able to make that determination, and that's what the judge to make that. And that dismissing their, or should I say, denying their motion to dismiss, that's a pretty straightforward approach. Most cases will die at that moment, that motion for summary disposition situation where you're saying, Judge, they failed to state a claim. But this one, there's a claim there that has legs, it just doesn't have a window.
I know that most people watching, if they were to buy a window seat, they're probably like, I'm expecting a window seat, but does the airline have a stance here? You know, does it come down to the fine line, the wording that people are signing up to? You know?
It comes down to the wording for sure. It's what's in the contract. And so I mean, I know what's not in the contract. There's specific language that talks about we're agreeing to get you from place A to place B without a time restriction. So a lot of lawsuits in the past would come up where they say, you didn't get me there on time, and because of that, I'm going to sue you. They're crystal clear within their language that we haven't agreed or contracted with you to get you at a specific time. We just agreed to get you from here to there. It may take 6 more hours than we contracted, but guess what? That's part of the agreement. In terms of the seat, yes, you've contracted to buy a seat on the flight, but the selling of it, this would be, you know, unfair, deceptive trade practices. There are a number of claims outside just breach of contract that you brought me in with the expectation that I'm getting one thing and I'm getting something entirely different. So I think that, yeah, you can attempt to say the argument that they did, which is that we're selling you a seat that's closest to the location, not the aisle, but it would have to be defined and it would have to say in their contract. There is no guarantee of a window seat, even though you're selling it, selecting it as a window seat.
If the passengers that are filing this, if they were to win and damages come forward, do you see a court telling United or any other airline going, okay, you're going to have to now classify, you've got aisle, you got center, you got window, and then now you need to define window area, windowless or
you
something.
have, a seat with that is a window seat but doesn't have a window.
Doesn't have, like, are they going to have to define the language?
Expressly declaring that, yeah, there is no window seat. It's just a seat that's not in the aisle, right? But also, as you mentioned, it could be some type of declaratory judgment. And oftentimes in lawsuits like this, the damages that you recover are low, not nominal, but they're just not going to be like life-changing. And so it could be make a declaratory judgment and make an injunction, declaratory judgment saying that, yes, they breached the contract. I want you to make sure that you let them know that. But then also moving forward, there can be language in there to say, stop them from doing this, selling these types of tickets, so no future harm could happen. Because remember, even if you're successful as a plaintiff, you still have to pay for legal fees. And so the pay to get to that point to win a motion for summary disposition is already going to cost them thousands of dollars just to get to that point. And so, yes, if you're successful at the end, hopefully you're getting those things that I mentioned, but you're also getting your attorney fees back because you had to pay for this when you were duped into buying the seat anyway.
Yeah. All right, Khalif. Yeah, crazy. All right, appreciate that. Thank you so much. More topics with Khalif coming up here next hour.
Queen City News Plus. Just search Queen City News on your smart TV's app store.